The railway may accept higher liabilities if the consignor declares higher value in forwarding note and pays higher freight. Railway shall not be responsible for any damage arising from the freight or restiveness of the animal. Carriage of passengers' luggage. The railway is not liable for the personal luggage of a passenger which has not been booked and which the passenger takes with him at his own risk. Articles of special value. When the valuable articles mentioned in the second schedule are contained in any parcel or and the value of such articles exceed rupees 10,000, the railway shall not be responsible for the loss, destruction, etc., unless the person delivering has declared the value and contents in the forwarding note and has paid a higher freight. When any parcel whose value has been declared, the compensation for the loss shall not exceed the value so declared. A railway administration may examine the parcel before accepting it. Accident of passenger. If a passenger dies or gets injured as a result of railway accident, the railway shall be liable to pay rupees 100,000 to the heirs of the deceased and rupees 10,000 to the injured passenger. Accident of a person. If a person other than the passenger dies or gets injured as a result of railway accident, the railway shall be liable to pay rupees 100,000 to the heirs of the deceased and rupees 10,000 to the injured of the accident if it is proved to have occurred due to the railway's negligence. Goods falsely described. The railway shall not be responsible for the loss, destruction, or deterioration of any goods which have been falsely declared, and if the loss, destruction, or deterioration is in any way occasioned by the false declaration, they don't have any liability on it. Notification of claims. A person is entitled to refund of an overcharge in respect of animals or goods carried by the railway, or to compensate for the loss, destruction, or deterioration of animals or goods unless his claim has been made in writing within 6 months from the date of the delivery of animals or that of goods. Now we get to the next topic, which is called carriage of goods by sea. The law relating the carriage of goods by sea is contained in Carriage of Goods by Sea Act 1925. Contract of affreightment. A contract between the ship owner and the consignor whereby the ship owner agrees to carry cargo within specified time and return for a specified freight is called a contract of affreightment. Charter party. A charter party is an agreement in writing for the purpose of hiring of the whole ship or a part thereof for the purpose of carriage of goods. The person who hires the ship is called a charterer. What are the kinds of charter parties? Number one, voyage charter. When ship is chartered for a particular voyage, it is called a voyage charter. A voyage charter is a contract to carry goods on a particular voyage to a port. Time charter. When ship is chartered for a particular period, irrespective of the number of voyages it may have to undertake, it is called a time charter. Charter by demise. In charter by demise, the owner gives up possession and full control of the ship to the charter of a certain period. The charterer has the right to appoint his owner is the charterer has the right to appoint his own captain and crew. Charterer bears all expense of operation along with legal responsibilities. Owner of the ship gets stipulated hire. Clauses for the charter party. We'll discuss them in our next video and we'll talk about them in details.